That's my baby child. Everybody here who is coming that we know of?
Yes, sir.
All right, we'll go ahead and go on the record and open this hearing. This morning we're here for the appeal hearing of Mr. Michael Snipes. The board is ready to go, and we have a couple of housekeeping details. First of all, before we begin the actual hearing process, I would like to ask Mr. Mose to speak briefly.
Good morning, Tom Mose, the Human Resources Director for the county and also the Secretary of the Board. The last several hearings, we've had numerous procedural and evidentiary type issues become before the board, and as such, the board has had no one here to represent them to help them answer those questions. So I contacted Mr. Lane last week and asked him if the board would like an attorney here this morning representing the board. He said yes. So with us this morning is Mr. Jeff Mendel with the firm of Fisher and Phillips out of Orlando. He's here this morning and will represent the board. He does not represent county staff or Mr. Snipes here today. I just want to make that clear to everyone. He's here to represent the board and only the board.
We appreciate that. Thank you for being here.
I am going to recuse myself from this hearing. I've known Todd, you call him something else, just Todd, since he was about that big. And I know the family, and I don't think it's appropriate that I sit in on this hearing. I think it's too close. So I'm going to recuse myself.
Appreciate you taking the time to be with us anyway, and look forward to the next hearing. Appreciate it. Typically, and I think I'll do it again today, go around the room and just introduce everybody so we have it on record for who's here. Go ahead and start with Tom. You've already.
Tom Mose, Human Resources Director.
Ginger Hadley, listener.
Todd Snipes.
Attorney Jason Carr on behalf of Mr. Snipes.
Nancy Jones, Assistant County Attorney representing the county.
Larry Smith, Deputy County Attorney, also representing.
George Eichenwald, Director of Public Protection.
Amy Woodford, Paralegal, Republican Party.
I'm Zell Reeves.
Brenda Thompson.
Patrick Lane.
Fran Duval.
Joe Wigger.
And Jeff Mandel, legal advisor to the personnel system.
Make sure I don't screw it up again. Not really. Okay, we'll go ahead and swear in any witnesses that are here. Do we have a group of those? Sometimes that's necessary, sometimes it's not. If we just have one or two, we'll just wait.
I'm sorry, we have one more matter we wanted to bring up. If you want to swear the witnesses first, that's fine, but before we get started, we wanted to bring up an issue regarding Mr. Carr has listed as a witness, or has listed as a witness, I guess, but has requested that Mr. Deneen, the county manager, appear before you and testify today. We do not feel that that's appropriate. He is the final decision maker in all discipline, as you know. He has to rely on your findings of fact when he makes his final decision on discipline. We believe it would be improper and inappropriate for him to testify here before you today. He is certainly willing to come over here if you feel that it's appropriate for you to hear from him. He is not a fact witness. He has no personal knowledge of any of the specific facts that resulted in the discipline in this case. I think I can give you an example where he might possibly ever be a witness before you, and that would be if he actually witnessed an employee doing something, sleeping on the job or drinking on the job or something, then he could be a fact witness that you would need to hear from, but that is not the case here today. So we want to place an objection on the record to that, and we're hoping we could resolve it earlier rather than later so that we could release him and let him know that he can go forward with his day.
Kind of unusual that you subject him to a subpoena or anything like that?
We requested the subpoena twice.
And what was your reason for wanting to hear it?
Well, because one of the issues that's going to be before the panel here today is the punishment that was given to my client, consistent with the punishment that Mr. Deneen has levied out in the past. There's an issue here with an office assistant by the name of Janice Riker, who was accused of the same social media violation of which Mr. Deneen was part of. In addition, on August 17, 2013, Mr. Deneen was quoted in the Daytona Beach News Journal as saying he was, quote, angry at my client. So it would appear that he does have knowledge of what's going on here. He may have factual information which is pertinent to our case here today.
Okay, thank you. Comment on that? Any reason like
I would like to clarify for the record that the actual comment was that Mr. Deneen was angry at the comments and the messages, not at Mr. Snipes. The quote from the newspaper is that he's angry at the comments and the messages.
And that's what we're here for today, the comments and the messages. Exactly.
All right, well, I appreciate getting out on the table. I don't think we're going to suspend the hearing. We don't have him show up if he doesn't show up, but I understand you're interested in coming. I don't know that we need to make a ruling on it.
Well, I want to be clear that he is willing to come if the board feels that he needs to be heard from, but we believe that that would be improper, and that his job is to be impartial, and getting involved at this stage of the proceedings would be wrong.
Well, just off the top of my head, I feel like we can get the information on the comparable cases and whatnot from other sources. Anybody on the board feels wrong that he needs to be here today. It's pretty unusual that he would show up since he is the final arbiter of the decision.
Under the county attorney, that I think it'd be inappropriate.
I don't think unless we get to a point where we absolutely need him, we don't really need him. Unless I hear any strong dissent, we're just going to go ahead and proceed. I'll take that under.
But he has been subpoenaed.
That's a soft subpoena. I don't know exactly.
Well, I
how
know
much-
that.
I hand delivered it to him myself.
Okay.
And
so
that's why I'm telling you that he knows that he's been subpoenaed. It is a soft subpoena, but he is certainly willing to come if the board feels that he's here.
Not everybody gets a subpoena, so
There's another issue.
Yeah.
Madam Roberts, there's another issue today, and that has to do with counsel for the county.
Hang on 1 second.
No, I'm just waiting, I'm waiting
Okay.
for the time when you need the witnesses.
Okay.
I was gonna get them.
All right.
As we know, the personnel rules require sequester of all witnesses. One of the other witnesses that has been named here for our purposes today is Assistant County Attorney Nancy Jones. Therefore, we believe it would be entirely proper for her to be here during the testimony of other witnesses. And if the board needs reasons why, and will allow me to approach.
Yeah, I'm sort of taken aback by your objection.
Well-
Can you repeat that for me again? Maybe I didn't hear you.
Well, Nancy Jones, the county attorney, has been listed as a witness. One of the reasons she has is one of the problems that we have with the audit that was conducted by the county was that the county failed to acknowledge and abide by the law officers' Bill of Rights, which are in play here today. One of the things the county did, and it will come out through the evidence, was it withheld the name of the original informant that went to the county, one Scott Dowling. It wasn't until I raised the issue with Ms. Jones that I finally received a letter on November 1st confirming, in fact, the name that had been withheld, despite numerous sunshine law requests and a requirement under Section 1112, 532, subsection 1, subsection 5, that all claimants be identified. The county failed to do that. They actually withheld the name. In fact, when you look at Captain Vanis's report later on, you will find that he purposely kept the name of the original informant anonymous, despite his requirement to do so. Therefore, we believe that Ms. Jones has vital information regarding the IA, which is what's brought us here today, and therefore we have listed her as a witness. This is of great concern to us. And I'm ready, and I can show this to the chair if you'd like to see this, sir.
Let me just, before we get much further, do we have other witnesses that are in the room that are going to testify today?
I don't know
I
here.
think we've kept all of our witnesses.
All right,
So, except for George.
that's fine.
Yeah, he's not.
So, is that, are you saying that you didn't get all of the information?
Right.
Is that your response?
Sure, absolutely.
Okay, if I may respond.
And what I'd like to also show the chairman is the rule that I was referring to. And it says, quote, the law enforcement or correctional officer under investigation must be informed of the nature of the investigation before the investigation begins. And he or she must be informed of the names of all complainants. It is clear from that letter that did not happen here by the county.
Well, would you like to respond?
Yes, please. I was not involved in this internal affairs investigation other than Mr. Har, when Mr. Har requested an attorney from the legal department to come when his client was being interviewed during the internal investigation. So he requested that an attorney from our department sit in on the interview, which I did. I did not withhold any witness names. I do not, Scott Dowling is not a witness for the county. I was informed last week, which is when I wrote the letter to Mr. Har, that Mr. Dowling was the source of the original source of the information that was given to Director Swanson. Some of this may not make sense to you because you haven't heard the evidence yet, but Beast Director Mark Swanson is the one that made the complaint in terms of asking his supervisor, Mr. Rectenwald, to open an internal investigation when the text messages and the Facebook posts were given to Mr. Swanson. They were given to Mr. Swanson apparently by one of the recipients of the text messages, a former Beach Patrol captain named Scott Dowling. Issues regarding the Bill of Rights, you all have, Mr. Ball has not had an opportunity too much of this, but in the previous hearings that you all have had, this issue of the law enforcement officer's Bill of Rights has been raised. And it's the county's position that that's not relevant to what you do. The Bill of Rights is something that comes into play when the officer is under investigation. It requires that any interrogation be recorded, that he be allowed counsel. That's what that document that he just showed to you provides for us during the internal investigation. It also provides for a remedy. If the employee thinks that his rights have been violated during the investigation, he has a remedy to go to circuit court. That remedy is not to come to you and ask that something be excluded. We do not intend to call, we did not list Scott Dowling as a witness. We do not intend to call Scott Dowling as a witness. Mr. Swanson is prepared to testify to you where he got the information from and what he did with it. And that's what is relevant to your finding today. This is a case where the employee has admitted some of the acts with which he was charged, which were the acts that resulted into the discipline. Therefore, where the information came from, in our opinion, is not really relevant to you. That's not why anything was withheld. Nothing was withheld from the county attorney's office. Yeah, the other thing is, I'm not a fact witness either, as with Mr. Deneen. I know nothing. I have no personal information about the facts of this case, which is what your job is the finders of fact, to determine the evidence that resulted in the findings against Mr. Snipes. Whether or not there was evidence to support the allegations in the letter that you have a copy of in the violations. I don't have any personal knowledge of that. I have no knowledge whatsoever about anything to do with that. I have not spoken to Mr. Dowling. I have no idea what he might say.
Can I help move us forward on this? It seems to me at this point, what the parties are doing is arguing over the application of the law enforcement officer Bill of Rights and moving away from the initial issue that was presented, and that is whether or not Ms. Jones should essentially be disqualified from serving as counsel in this case because she's a witness. And that, as I understand it, that was counsel's motion, essentially to say Ms. Jones cannot act as attorney in this case and she's a fact witness. Recusing an attorney, the party's choice is an extraordinary remedy, but one that is warranted under certain circumstances. And the things that you all have to look at in making your determination is that, are there avenues available to provide the information necessary for Mr. Hurd to present his case, short of disqualifying Ms. Jones and essentially telling the county that they can't have the representative they're choosing? I don't know. At this point, it doesn't sound to me like there is a dispute of fact. You have the document in front of you. Maybe the parties can work out a stipulation to avoid this issue.
One other point I wanted to make is that Mr. Hard did request and was given a subpoena for Scott Dowling. Now, it was given to him, I don't know if he had it served, but that was done the beginning of last week, as I recall. Mr. Most might remember for sure, but I believe it was last Tuesday. A letter was received asking for a subpoena for Scott Dowling from Mr. Hard. So he had the ability to bring him here with the subpoena that was provided to him. So I don't know if that adds anything to the discussion. But.
All right, I think I've heard the complaint and I've heard the response, but I'm not problem with it. I think unless there's a problem with other board members, I'm not going to ask her to recuse herself from the testimony today. We are a fact-minded board, and if there's something else that comes to our light that you need to share with us in terms of concern on your part, I'm sure you'll do it. All right.
The witnesses to be brought in now.
Yes, please.
Thank you.
Board members, we're going to turn this, Ms. Jones and I turn this so we can face you during openings. This might be a little odd.
Seriously, you're going to stand behind the podium? That's my official of you. You can stand wherever you're comfortable standing.
Just so we can hear him.
No, I don't think it.
You'll have no problem hearing me.
No, seriously, I take this seriously. Seriously, I have to say, this is an atypical setting. I've not been in this room before, so I don't really know the logistical setup here either. We'll stumble through it, and we'll all be fine.
Mr. Lane, almost all of the witnesses are here to be sworn. Mr. Vanis went down to the restroom at this inopportune time, and he, as soon as I see him coming down the hall, I'll usher him in. That's
Well, we'll just take it. All right, if you are going to testify.
Oh, here we go. They're on.
Perfect timing. If you're going to testify, would you please raise your hand, please? In the matter before us this morning, you hereby solemnly swear to tell the truth, the whole truth, and nothing but the truth. Thank you very much. I appreciate that, and we'll ask you to wait outside. We'll call you in individually when the time comes. Thank you. All right, any other housekeeping issues?
Sorry, no, sir.
Okay, then we'll proceed with the opening statement from the county, please. I know you guys are going to be more comfortable standing behind the podium.
You guys okay with me standing over here so I'm not in the way?
Yeah, that's perfect.
Okay, I can talk loud too. My usual problem is that I talk fast. You all right with the lights down? Mr. Carr, you guys okay there?
Yes.
Okay. In January 2013, Mark Swanson was appointed as the director of the Volusia County Beach Services Division. The Beach Services Division is a nationally recognized beach department. Those of you that have been around here for a while are familiar. There are lifeguards in the Corps, there are law enforcement officers. It's well-respected and has been a well-respected organization until about 5 years ago. Again, those of you that have been around the area are probably familiar that in the last 5 years, the beach department has come under a lot of attack. And it's been a rocky road for them and for the employees that work there. So in January 2013, when Director Mark Swanson took office, he came to the table as a veteran law enforcement officer, as a 31-year supervisor with the EVAC department, and with a lot of good ideas. And one of the things, one of the goals, and you'll hear him say it, is that he wanted to start to improve the reputation of the beach department. Now, this was not something totally new, because you all heard before from Mr. Reckenwald that when he was appointed the Department of Public Protection Director, that he also wanted to start working on the image and the reputation of the beach department. It was for the hardworking members of the department that were really maligned by a lot of this bad press over the last few years. When Mr. Swanson took office, he, like Mr. Rectenwald, met with each and every employee. And he sent a message to them. He told them a lot of things, and he'll tell you that he talked about change in the department, helping to improve the image. But he also told them that he would have zero tolerance for any conduct by any employee that would reflect unfavorably on the department. You can understand why he would do that. And he used a very interesting phrase. He said, if you wouldn't want to see it in the paper tomorrow, don't do it. You will hear from Mr. Swanson that he felt like his message was clear and understood by the members of the department. The case that we're here on today involves a person who's been in that department for 24 years, a long time. The point of that is that he had been there through all of the bad publicity and knew what the problems were and that the image, the reputation of this fine organization had been damaged. Also in January 2013, the county instituted what has been called a social media policy. Now, some of us dinosaurs aren't as up to speed on some of the Facebook and all that stuff, but essentially what the social media policy says is, don't put something on your Facebook or on the internet or on any sort of media that could be sent out into the internet world that would reflect unfavorably on yourself, the person that's doing it, or on the county. Don't do it. Don't put anything discriminatory, harassing, violent. Don't do it. And if you do it, if you put something on the internet or on your Facebook page that could reflect unfavorably on you as an employee or on the county as an employer, then you're subject to disciplinary action up to and including termination. So here's the point of what I'm telling you right now. In 2011, Mr. Reckenwald told them zero tolerance. In 2013, Mr. Swanson said zero tolerance. In January of 2013, the county said zero tolerance. Mind yourself, mind what you're doing, mind your conduct. Every employee was required to sign the social media policy. They had it, they read it, they understood it, signed off on it in January of 2013. Fast forward now to July of 2013. July 13th, Saturday night, about 10 p.m. George Zimmerman is found not guilty in a very high-profile case involving 17-year-old Trayvon Martin. Some people might call that a verdict heard around the country, because if you were alive then and reading the paper or watching any kind of media, you know that there was a very large human cry, and it was very polarizing. That was on Saturday night, July 13th at 10 p.m. The next day, July 14th, before 1 p.m., Beach Captain Michael Todd Snipes posted something on Facebook. And this is what he posted. I don't know if you can read that, but it says, another thug gone, pull up your pants and act respectful, bye-bye thug, R.I.P. He has admitted in the Internal Affairs investigation that he was referring to Trayvon Martin when he posted that on his Facebook page. He had some 330 or so Facebook friends, so that post was open to those 336 or whatever people could have seen it. We don't know how many people saw it or maybe even passed it on. We don't know, but It was seen by, or it was available to be seen by at least 330 people. Some of them subordinates within the police, the beach department, some of them not beach or employees of the county at all. Mr. Snipes went to work that day from 1 to 9, and he was working what they call like an outside detail. They're law enforcement officers, they're paid through the county, but a private company, in this case the Ocean Deck, hires them to do law enforcement services. The county bills that restaurant or Ocean Center, whatever it might be, for the services, but the officer is acting as an officer. He's in uniform, with gun, badge, press powers, and all that, from 1 to 9 p.m. At about 4:30 or so, I'm sorry, about 8:30 during this shift that he's working, Mr. Snipes decides to send what's called a group text message on the cell phone. And what a group text message is, for those of you that may not know, I had to learn a little bit myself through this, is that the person that initiates the first text sends it to a group of people, whoever they select in their phone. In this case, he sent it to 9 other people. 3 of them were all current beach employees. 2 were subordinate in rank to him. 1 worked directly for him. And so while he's at work at the Ocean Deck at 8:30 or so, he sends this picture to those 9 people. Within a few minutes, and how a group text message worked is that if someone else in the group sends a message or a picture, it goes to all the people in the group. So what ended up happening here is someone else in that group text message that Mr. Snipes initiated sent the second photo that came in. All of this in a fairly short period of time. And that was the second one that was sent to the group. When that text message came through the group of 9 and 10, including Mr. Snipes replied to that text message. And he replied LOL, which in text message language means laugh out loud. In response to that text message picture, another person in the group of 10 sent this picture, and then shortly thereafter, well, I'm sorry, the next day, stop right there, please, thank you. So the night ends when he's still at work with the last picture of the I smell wet grass picture. The next day, which would be Monday, July 15th, Mr. Snipes worked from 7 a.m. to 7 p.m. for the beach department in his regular duty. He supervised approximately 6 law enforcement officers and 20 lifeguards or so. And at about 4:30, somebody in this group text starts it up again and sends this picture. And the caption on that picture said, George Zimmerman, jury. While at work, Mr. Snipes responded to that, LOL, nice. Laugh out loud, nice. And then he ended this with a final picture sent by Mr. Snipes of this. Mr. Snipes was using his personal cell phone when he was doing this, but his personal cell phone he also uses for county business, and you'll hear that that's not unusual. Supervisors are issued a county cell phone. A lot of them don't want to carry 2 phones, so they use their personal cell phones and they conduct county business. There's no dispute that he used his personal cell phone for county business. There's no dispute that these text messages were sent while he was working. The Facebook post was not done while he was working. That was on Sunday before he went to work. But all of the text messages, those that he admitted sending, which were the very first picture that started all this, was sent by him. The LOL comments were made by him by his own admission. And then he sent that last picture on Monday. So this was not a case where he blurted something out or he posted something and then realized, oh my gosh, I shouldn't have done that, and stop, let me make amends. This went on from Sunday morning until Monday, late afternoon. These are the facts that you will hear testimony of today. And what's important for you to know at this point is what happened. How did the county, because you've heard a little bit about this. One of the people that received the text, apparently, reported this to Mr. Swanson the very next morning at 7 a.m. So this happens on Monday, late afternoon, the last post picturing. And it's reported to Mr. Swanson at 7 a.m. And he immediately contacts the Internal Affairs investigator, Captain Vanis, and tells him, gather all this up, reports it to Mr. Rechtenwald, and an internal investigation is immediately initiated. It wasn't a very long investigation. The other employees who were in the group text were interviewed. None of them passed the text on to anybody, forwarded it to anybody, or responded to any of the texts. When Mr. Snipes was interviewed, he admitted that he had posted the Facebook post and that he was referring to Trayvon Martin when he said, R.I.P. Thug. He admitted that he initiated the first text in the group text, the picture of Paula Dean with the caption. He admitted that he had put LOL into the picture of what appeared to be a caricature of Trayvon Martin and the words, "These Skittles were to die for." He admitted doing that. He admitted carrying this on into the next day and doing LOL nice about the George Zimmerman picture, George Zimmerman jury picture. And he admitted posting the final picture or sending the final. These are the facts that were used in disciplining and determining that Mr. Snipes had violated certain directives of the beach department. You will be given, during the course of the hearing, a copy of the Beach Services Directive. It happens to include their Standards of Conduct Directive, happens to have the merit rules as well at the beginning. So you only have one document that will show you what the violations were. But he was charged with violating the Code of Conduct for employees of county government. And keep in mind that government employees are held to a high standard, and law enforcement officers are held to an even higher standard. He was charged with violating the Code of Conduct, which says employees of Volusia County government are employed to provide service to the citizenry of Volusia County and the public in general, and are expected to conduct themselves in a manner that will reflect credit on the county government, public officials, fellow employees, and themselves. He was also charged with sending derogatory or ethnic remarks, or making derogatory or ethnic remarks. Employees shall not make derogatory remarks concerning race, sex, religion, age, or national origin of any person. He was also charged with the merit rule, any conduct on or off duty that reflects unfavorably on the county as an employer. And finally, he was charged with 11.01 of the directives, which say it shall be the policy of the Beach Services Division that employees maintain command of temper, patience, and discretion. They shall not engage in any conduct which constitutes neglect of duty or which is likely to adversely affect the discipline, good order, or reputation of the division. Ladies and gentlemen, this isn't just about a Facebook posting or text messages that were sent that were clearly inappropriate, and even by his own admission could be considered racist or offensive. This hit the media within 2 days of Mr. Swanson becoming aware of it. I don't think anybody knows how it was given, how the media got a hold of it, but they got a hold of it. And it became front page news again for the beach department. Mr. Snipes was disciplined. He was terminated because of his actions in this case, because of a conglomerate of facts that you will hear about and that I've told you about today that left Mr. Rechtenwald no choice but to terminate him. And at the conclusion of the hearing, we'll be asking you to uphold that discipline and find that he in fact violated these directives. Thank you.
Mr. Mark?
I guess I can stand here too and not behind the podium.
Seriously, you gotta look at that.
I'm fine. Panel members, good morning. My name is Jason Hart, the Har Law Firm. And I have a unique perspective on this case. Aside from being charged and being hired and having the pleasure of representing Mr. Snipes, I have a master's degree in public administration from the University of Miami. So I was learning about public government long before, actually not long, but before I even attended law school. And I took, when I was at the University of Miami, administrative law classes, and I learned a little bit about the process prior to starting here. This much I know about this process that we're getting ready to go through here today. It's not my burden of proof. Burden of proof here today lies with Ms. Jones and Volusia County. And the burden is basically to show two things. Number one, whether or not Mr. Snipes violated policy, and number two, the punishment that Mr. Reckenwald issued in this case, was it fair and consistent with how the county is run? Well, obviously I'm going to have a little bit different take than Ms. Jones. What I'm going to do is I'm going to make the argument that what you saw up there, as Ms. Jones has indicated, primarily was sent by other people and not my client. What you saw up there that my client sent out was this picture that contains no ethnic remarks that could be deemed racist, but merely a picture of what looks to be George Zimmerman, and I don't know who the other person is. I don't think any of us do. Then he's accused, and I'm not going to pull down that thing, of sending out this picture. And you're being asked to determine that this violates the policy. This is a cartoon picture of Paula Dean that, depending on how one wants to interpret this, appears to make fun of Paula Dean. Why? Because we know, in addition to the fact there was a Trayvon Martin case, there was a bigger national case made out of something Paula Dean said. So the issues here for you to decide have to do with whether or not this cartoon that my client sent to 9 people privately. He used his private phone, that is correct. Wasn't made public, wasn't intended to be made public. He didn't make it public. He didn't do anything to make it public because he was concerned about the reputation of the county. Now, why did someone else make this public? We have a theory. The theory is most of the press have a standing sunshine law request that if the county opens up an internal investigation, an IA as they call it, that gets reported to the press. So that's our theory. Then there's the issue of the Facebook page, the RIP thug. Once again, and I have to admit, I'm not on Facebook. I was for about a month and realized this is not a good idea for me. So I'm not on Facebook. So I had to learn a little bit about this. Michael Todd Snipes has a Facebook page. If we were to log on to it, if Jason Haar was to go log on to Michael Snipes' Facebook page right now, I couldn't see anything on it but maybe a picture and who he is. Why? Because I need to be his friend. He has to accept me as a friend. There's an actual hurdle that has to be made in order for me to be part of this. Now, the question becomes, those people, once again, this is not public. My guess is companies like Pizza Hut have, and maybe even the county, I don't even know, has a Facebook page where you don't have to become a friend and you can just view it. So anyone can view it. So my client's Facebook page was not visible to the public. However, the county once again has the burden of proof, proving in fact that this was racist. Okay, well we assume then that the county will present testimony of some of the Facebook followers of Mr. Snipes who found it racist. We anticipate hearing that testimony. The policy that my client is accused of violating is policy number 11.01.56, derogatory ethnic remarks. Employees, and I will quote the policy, employees shall not make derogatory remarks concerning race, sex, religion, age, or national origin of any person. Then there's a citation and it says in parentheses, violation subject to dismissal. Well, we're going to make the argument that what my client did was not make derogatory remarks concerning a person's race. He made a derogatory remark, arguably, about a case that was in the news. Now, if you want to take that case and say, well, that's a matter of that was a you know, matter of race. Well, no, that was a criminal case that was tried in a courtroom in Seminole County by a jury of peers. To my knowledge, there hasn't been any appeal of that verdict due to racist problems that may have occurred during that trial. Now, one of the other things that we need to talk about here is the text that he said in terms of those 9 people. Under the Law Officers' Bill of Rights, the person who the county selected to conduct this internal investigation is a gentleman by the name of David Vanis. One of the responsibilities Dave Vanis had was to interview all witnesses. What you will hear from John Texter, Michael Berard, and Russell St. John, 3 of the 9 people who received the text. In fact, you will also hear and probably view their interview statements. None of them found it racist. None of them reported it to their supervisors. Why? Because it didn't violate policy in the first place. Those are employees who arguably could have gotten in trouble themselves for covering up a violation, such multitude of violations. Yet none of them, and that's why, instead of taking the statements of the remainder of those 9 people, as he was required to do so under the Law Officers' Bill of Rights, Dave Vanis shut down his investigation and rushed to a conclusion that there had been a violation. Yet there hasn't been any testimony provided by anybody who was part of the IA that they found this racist. The only people who have stated that they found it racist were people who didn't receive the text, such as George Reckenwald. Now, let's talk about this. We're going to show you a picture of a cell phone, and it's going to have all these different numbers, including that of Scott Dowling. Scott Dowling is a major issue for us here today. Scott Dowling was the anonymous source that Dave Vanis refers to in his internal investigation report that he submitted to Mr. Reckenwald. The county doesn't have the privilege of an anonymous source under the Law Officers' Bill of Rights. They had a duty to disclose why this former employee decided to take this matter to Mr. Schwanson. We don't know why. And unfortunately, as we go forward today, we're not going to know because Scott Dowling isn't here. Why isn't Scott Dowling here? Because it wasn't confirmed until November 1st by Ms. Jones, county attorney, that Mr. Dowling was the source of this information. Now, Scott Dowling was part of the 9 who received the original text from my client. And I ask you, panel members, why wasn't his statement taken? And I ask you to weigh that in terms of when you make your decision. Why is it the original complainant who turned this in, a former employee, why wasn't his statement taken by Vanis? Once again, we have a theory. It isn't because he thought the text was racist. He did it because he had a personal axe to grind with my client. Why? My client has served the people of Volusia County since he started as a lifeguard at the age of 17. Ms. Jones was correct. The county has undergone some issues with, unfortunately, some past employees, which have been embarrassing. However, Mr. Snipes hasn't been part of any of it. 24 years. If I asked him under oath how many lives has he rescued out of the Atlantic Ocean, he can't truthfully tell you. It's in the hundreds. How many arrests has he made? He can't tell you. It's been so many, protecting and serving our community. For 24 years, this man has served. Has he ever been accused prior to today of being a racist or making a racist comment? No, he hasn't. This is 24 years of exemplary service to our county. We assume you'd be seeing, if he wasn't, we assume you'd be getting ready to read about all these disciplinary reports that came through. Now finally, to my second point. And that's essentially, with the punishment issued by Mr. Reckenwald consistent with past social media violations. Ms. Jones and I have had this conversation. Fortunately, she and I have had an open line of communication throughout this process, which I appreciate because I think government needs to operate in the sunshine. And this is one of the things we talked about. I'm going to show you what we sent 2 sunshine law requests specifically for information from the county of people who had been charged with the same violation as Mr. Snipes. What I got back was largely unresponsive. It didn't have to do with what Mr. Snipes had been charged of. But there was one case where an office administrator was accused of social media violation. She was not terminated. So what I ask you to do with the finders of fact here today is to wait for the testimony from those who received the text, or wait for the testimony of those citizens who are going to come in here who are going to say this was racist, and this has somehow impacted the government's ability to operate, as Ms. Jones put it. The only thing that we've done so far is we have suspended a law enforcement officer with 24 years of exemplary service who only wants to serve us as citizens of Volusia County. That's all we've managed to do. Thank you.